A Florida appeals court decided that a hospital can kidnap a child and get away scot-free. And when the child's mother takes her own life out of anguish, the hospital is immune. Welcome back to Bankruptcy with Ben. And the case we're talking about is one that inspired the Netflix documentary Take Care of Maya. It made national news when in 2023, a Florida jury awarded Maya Kowalski and her family over $200 million after the hospital kidnapped the child and then engaged in a series of acts that no child should ever be made subject to, that no family should ever be made subject to. And when the mother took her own life, the hospital, according to the Florida Appellate Court, cannot be held responsible. And now the question is, what are the Kowalski's options next? Can this case go to the Florida Supreme Court? So, by way of quick background, in Florida, as in most states, there's 3 levels of courts. The trial court is the lowest level that hears the trial. The next court after that is the appellate court. That's the intermediate court. After that is the state Supreme Court. In Florida, this would be the Florida Supreme Court. Now, not every case is able to go to the Florida Supreme Court. There's very, very specific sets of circumstances that you have to show. It's called question of great public importance. And, well, that's not clearly defined of what is considered a great public importance. Very, very loosely, it means it has to be something involving some kind of public policy that's going to impact the public as a whole or impact somebody's fundamental rights. And I think this case meets all of those criteria. And I'm going to break it down for you. We're going to get into the decision. I'm going to explain why I think this is a very, very strong case to go to the Florida Supreme Court. Tell me what you think in the comments below. Without further ado, here we go. Okay, District Court of Appeal of Florida, 2nd District. Johns Hopkins All Children's Hospitals, Inc. appellant versus Maya Kowalski and Jack Kowalski, individually and as personal representative of the estate of Beta Kowalski, deceased. That was the mom. All right. We're not going to go through the whole decision. I'm going to go through some of the key facts, and then I'm going to discuss the immunity issue where the Florida Appeals Court says the hospital is immune. And I'm going to explain why this sets up a case where a hospital, if this decision stands, can essentially get away almost with murder. Okay. The trial court's erroneous interpretation and application of Section 39.2031A of the Florida statutes, proceedings related to children. That is the statute which deals with whether or not a hospital can have immunity from liability in certain circumstances. And now that's the heart of the matter. Okay, here's the background. In the fall of 2015, Maya Kowalski was diagnosed with complex regional pain syndrome, CRPS. Beta Kowalski, Maya's mother and a nurse infusionist, became aware of CRPS prior to Maya's diagnosis through one of Mrs. Kowalski's patients. CRPS is a central nervous system disorder. It is characterized by severe regional pain with no apparent cause. Patients with CRPS experience an array of symptoms, including agonizing pain in the affected region or limb, extreme sensitivity to touch, light sensitivity, and lesions. Initial treatments for Maya's CRPS included warm therapy, physical therapy, non-narcotic pain medications, and opioids. When the initial treatments failed to relieve Maya's pain, Maya began receiving ketamine, and this is where everything starts to go haywire. This included Mrs. Kowalski taking Maya to Mexico, where Maya was placed in a 5-day ketamine coma. You can see how serious this is, to be placed in a 5-day coma. For a period of approximately 8 months prior to her admission to JHAC in October 2016, Maya was being treated with ketamine infusions through a central venous port in her chest. The ketamine infusions were authorized and overseen by Dr. Ashraf Hanna, a pain management doctor. Although ketamine had been the longest used and most successful treatment for Maya's CRPS prior to admission to JAC, Maya's physicians had also prescribed other treatments. During most, if not the entirety of her treatment, Maya was unable to walk without assistance and was in a wheelchair. So again, extraordinarily debilitating disease. On the day before Maya's admission to JAC, Dr. Hanna advised Mrs. Kowalski that he had given Maya the maximum dosage of ketamine that could be administered and that it was not helping Maya. Dr. Hanna advised that Maya be taken to JAC. On October 7, 2016, Mr. Kowalski brought Maya, then 10 years old, a little girl, to the emergency room of JAC. Maya presented with excruciating pain. Upon Mrs. Kowalski's arrival at JAC, she was adamant that Maya received ketamine infusions. And although JAC was unable to confirm with Dr. Hanna that Maya had been in his care and had been receiving high dosages of ketamine, the hospital ER notes state that dosages at the level demanded by Mrs. Kowalski could not be administered in the ER. Okay, so you already see the tension. Maya had been treated with ketamine before, and the mother thought that this was the best treatment to continue, but the hospital said it's too much. We can't do it in the ER. It's just too high a dosage. Maya was ultimately admitted to the pediatric intensive care unit at JAC. So it doesn't say here, though, whether or not the PICU could administer that dose. So unknown. Concerned about Mrs. Kowalski's demands for ketamine and perceived inconsistencies between Mrs. Kowalski's recitation of Maya's medical history and JAC's own observations, again, they don't say what the inconsistency was, but JAC for some reason thought that she didn't need ketamine, and Mrs. Kowalski, the mom, who presumably is very familiar with her daughter's condition, says that she does need it. But based off of this tension, they now suspect that there's some kind of child abuse going on because the mom wants to give this daughter this very, very heavy narcotics, and they think that's too much for this little child. So what do? They call the Department of Children and Family Abuse Hotline on October 7th, and then the following day, October 8th, JAC contacted Dr. Sally Smith because of the suspected abuse. On October 9th, 2016, a second call from a social worker at JAC was made to the Department Child Abuse Hotline. The second call resulted in an immediate investigation. So again, what was the difference between the first call and the second call? Why did the first call not result in an immediate investigation, but the second call did? Again, it's not clear. On October 13, 2016, Maya remained at JAC but was taken into the department's custody. But again, just as a way of background, it's not clear from what the appellate court is saying, but it could be the appellate court just didn't think that it was necessary to clarify that for the purposes of issuing this decision, right? The record is extraordinarily long, thousands of pages long, so we have to condense it all into a 48-page written opinion. On October 13, 2016, Maya remained at JAC but was taken into the department's custody. So she's still physically in the hospital, but legal custody is now gone from the parents to the department. So in 1 week's time, the parents no longer have the rights to their child. You think this is too rash a decision? Let me know in the comments. The department filed a dependency shelter petition requesting that Maya be placed in the shelter care of the department, meaning they're filing this, the department's filing something with the courts. Now you have this Florida agency, which is now filing with the court and saying to the court, we think Maya needs to be placed in our care and not the parents' care. Why? Because Maya had been abused, abandoned, or neglected, or was in imminent danger of abuse, abandonment, or neglect. Presumably because they thought that the ketamine treatments were too much. Which again, to be fair, to administer this level of dosage of ketamine is not a simple thing. So I can understand why the hospital is concerned. It's not something to be taken lightly to give a child that level of heavy medication. Now, obviously, the parents thought it was necessary, and as Dr. Hannah thought it was necessary, but you can at least understand what their concern was. The department sought medical shelter care for Maya and requested no contact between Maya and Mrs. Kowalski, but supervised visits between Maya and Mr. Kowalski and Maya's brother. So as long as there's supervision, some visits are okay. On October 14, 2016, following a hearing on the department's petition, Maya was placed in the shelter care of the department. The dependency court order provided that Mrs. Kowalski was to have no contact with Maya pending psychological evaluations of both Mrs. Kowalski and Maya. So you can see how things are starting to get a little bit out of hand. You have parents bringing their child to the hospital as if it's not bad enough that she's suffering from the CRPS. But now on top of that, now all of a sudden, because they wanted to treat their child, now their child is being taken away from them. So you're kind of adding insult to injury. At trial, Mr. Kowalski testified that at some point between October 8th and 13th, 2016, he and Mrs. Kowalski requested that Maya be released from JAC and that Jack subsequently threatened them with arrest if Maya were to leave the hospital against medical advice. Mr. Kowalski testified that Jack advised him that Maya could not leave the hospital because Maya had to be safely weaned off medications, including ketamine. Evidence at trial established that Jack attempted to transfer Maya to another hospital, but that the Kowalskis would not consent to the transfer because insurance codes on the transfer form indicated that Maya had Munchausen syndrome or the conversion disorder or was a target of Munchausen syndrome by proxy and did not indicate that Maya was suffering with CRPS. So 2 points. First off, if I'm the parent and I'm going through this and now I'm just trying to get my child treated, and now not only is my child not being diagnosed correctly, but then I'm being accused of abusing the child. And now I'm saying, okay, well, you want to take this child to a new hospital because you think a new hospital is going to give her better treatment, and you're obviously not happy with what this hospital has been doing. Well, you basically have to admit then that your daughter does not have this disease, which is why you brought her into the hospital to be treated. So what good is that going to do? And then not only that, as we're going to see, Mr. Kowalski testified that he and Mrs. Kowalski would not sign the transfer form because they believed it would mean admitting guilt or blame. Right. So, A, your daughter's not being diagnosed correctly. So how's the hospital that you're transferring them to going to treat her properly if they don't have the correct diagnosis? And B, you're admitting that you made it all up and that you're abusing your child, basically. And now you're going to forfeit custody of your child, which is what they thought would happen if they signed this. And can you blame them? No parent should have to be faced with that kind of decision. Mr. Kowalski testified that during one of his visits, Maya had asked him whether Mrs. Kowalski was in a mental institution. When Mr. Kowalski asked why Maya would say that, Maya told him that a JAC social worker assigned to Maya, Catherine Beatty, had told Maya that Mrs. Kowalski was receiving mental health treatment. Okay. Mr. Kowalski testified to additional statements made to him by Maya, including instances where nurses had told Maya that her illness was all in her head, that she's making the whole thing up. And where Mrs. Beatty had told Maya that she could be Maya's mother while Maya's there at the hospital. So you can't have your own mother and have some random social worker saying, oh, don't worry, I'm your mom. Mr. Kowalski also testified regarding his own interaction with Miss Beatty when she asked him, did you ever consider divorcing your wife? He responded, What are you talking about? And Miss Beatty said, oh, forget it, and walked away. Mr. Kowalski relayed to Mrs. Kowalski what happened during his visits with Maya and the information he had learned. So what do you think this did to Mrs. Kowalski's emotional state? And why is a social worker telling somebody that he should divorce his wife? What does that have to do with Maya's care? And it's just completely obnoxious. Maya testified that she was not permitted to speak with her mother and that this infuriated her. Of course, a widow goes in the hospital all alone and she can't even talk to her mother. Although Maya was told that her pain was in her head and she was making it up, Maya testified that she was not told that the physicians believed she had conversion disorder or Munchausen syndrome. So they didn't actually tell her what the specific condition was. They just said, oh, you're making it up. One instance Maya related involved a specific nurse verbally accosting her for not moving during a bed change. Despite Maya advising the nurse that she could not walk, stand, or roll, the nurse said, if you don't move right now or else. She recalled that the nurse yelled at her for quite a while, saying, I know you can move. I know you're faking it. Just stand up. We all know. The Kowalskis are Catholic, and Maya testified that she was not permitted to receive communion from a parish priest. She did receive communion from a priest associated with JAC. Okay, now 1 second here. And I'm not trying to disparage in any way the priest that was associated with the hospital. I'm sure the priest was a wonderful person. And, if you're working in a children's hospital as a priest, I'm sure you're there because you care about the children and you want to provide comfort and support to children going through kind of these diseases and just horrible things, right? So not a knock on the priest, but there's a world of difference between a priest who's a quote unquote professional and your family's priest from where you go to church. The priest that the Kowalskis wanted was presumably a priest that they knew, that they had a relationship with. It was from their own parish. Which do you think would have given more comfort and support to the family and to Maya? Somebody that they already know, who's a part of the family, who has a relationship with the family, or a stranger? I think the answer is pretty clear. And now, why can a community priest not have the ability to go visit the child? I don't understand that either. Again, it's very nice that the hospital has a priest on site, but that's not a substitute for the family's personal priest from their parish that they know that they have a relationship with. Maya believed that outside food, including the communal wafer, was not permitted because there was a fear that Mrs. Kowalski would tamper with it or somehow add ketamine to it. So now Mrs. Kowalski is suddenly a CIA spy or MI6 or part of the Stasi secret police, that she's tampering with food and injecting ketamine into her daughter's tuna fish sandwich. Okay, sounds a little more like a James Bond movie than real life, but that seems to be what the hospital believed. She did not testify to the requirements of the dependency court orders in this regard. Okay. Maya reiterated in her own testimony that Mrs. Beatty had told her that Mrs. Kowalski was in a mental institution. Well, that's just lovely. So on top of everything, now you're telling the little girl your mom's in a mental hospital? Maya quickly learned that Miss Beatty's statement was false. Wait, so you're being told your mom's in a mental hospital, and now you're being told that that's a lie. If it was true, it would be bad enough. And now the social worker who wants to be your mom is lying to you? And Maya believed that the statement was intended to manipulate Maya into thinking that her mother was sick and therefore making Maya sick. Maya also reiterated that Miss Beatty told her, I'm not trying to be your mother, but I can be. Okay, so what are you trying to do by lying to a poor child who's sick without her parents? Mrs. Kowalski was born in Poland, and Maya often spoke in Polish with her mother before her admission to JAC. Although the dependency court eventually permitted Mrs. Kowalski to have supervised phone and FaceTime calls with Maya, Maya was not permitted to speak Polish with her mother, and the calls were limited to basic and insignificant things. So now the hospital is regulating the language that a mother and her child can converse in. So the native language that is probably spoken at home quite a bit. No, you can't do that. You can't talk to your child in the language that you're comfortable with. And not only that, we're limiting even what you can, the substance of what you can talk about, as we're going to see next. An audio recording was played of one conversation when a female voice advised Mrs. Kowalski that we are not allowed to talk about the dependency case after Mrs. Kowalski told Maya that as soon as the judge makes a decision, she would be able to see Maya again. So, in other words, in my view, this seems to me a case of a mother telling her child, don't worry, this is going to work its way through the court system, and because we know we didn't do anything wrong to you and that you want to be with us as much as we want to be with you, which is, again, natural between a parent and a child, we just have to wait till the court works its way through the process. But we know we're going to be vindicated and we're going to be cleared because we did nothing wrong. So you're trying to comfort the child and tell the child we're going to be able to kind of get through this pretty quickly. No, you can't even talk about that. So the child is being regulated in the language she can speak. The substance of what they're allowed to talk about is being regulated. The frequency of how often the child can communicate with her parents is being restricted. And she can't even see her mother face to face. I mean, it seems to me this does not sound very reasonable. But let's go on. She also testified that whether Maya was permitted to see her priest was up to the dependency court. That's Miss B testified to that. Miss B testified that the department asked that Jack monitor Maya's calls and that at times calls came through Mrs. Beatty's phone and that she would put her phone on speaker to allow Maya to have the conversation. So she has to call the social worker who's lying to the child, telling her she can be her mother, accusing her of making stuff up for unknown reasons. And now she's the one who gets to be the filter and decide when, why, how, and to what extent the mother can talk to her child. At no time did the dependency court authorize in-person visitation between Maya and Mrs. Kowalski. So again, only phone contact. On January 6, 2017, the dependency court ordered that Maya would remain sheltered at JHAC. Okay. And set a February 2017 trial date. So again, these are the preliminary stages. So they said at the preliminary stage, we think that for the safety of the child, she needs to be put in the custody of the Florida Department of Child Services. But there's going to be a trial, and at the trial will be a final kind of merits-based determination. Mrs. Kowalski then took her own life the following day on January 7, 2017, leaving behind 2 notes. Terrible, terrible. Those notes reflect Mrs. Kowalski's sadness and frustration. I think that's a little bit of an understatement. The woman just took her own life, for God's sakes, because you kidnapped her from her child. You kidnapped her child from her. Her frustration with the dependency court proceedings and those involved with the dependency proceedings, including JAC, the department, and Dr. Smith. 1 week after Mrs. Kowalski took her own life on January 13, 2017, the dependency court allowed Maya to be released from JAC and to resume living with Mr. Kowalski. And then the kicker, it didn't even go to trial. The dependency case was ultimately dismissed. So what was all this for? I mean, unbelievable. So you can understand now the background, what spurred the family to bring this lawsuit. And just again, did the department dismiss the case because they realized wow, this went too far, we screwed up because the mom just took her own life? Or do they try to justify it and say, well, the mom's no longer in the picture, and I guess the dad's okay, so we can leave her in the custody of dad? Again, though, it was not, the petition was not to take her away from mom but not dad. It was taking her away from both. The operative Eighth Amended complaint was filed on January 24th, 2023. So again, I can tell you this is a lot of different versions of the complaint. The complaint, again, is the initial papers that start a lawsuit. It's where you're accusing the other side of wrongdoing. You're saying, John did X, Y, Z, and because John did X, Y, Z under the law, John is liable to me for $1 billion in damages. And then the other side could say, well, the complaint is bad because you don't actually, the law doesn't actually entitle you to what you're saying it entitles you to. So then you have a chance to amend it and say, okay, well, if we word it like this? This fits into what the law allows us. And you kind of go through this game of a whole bunch of different versions. Usually you have 1, 2, maybe 3 versions. So 8's quite a bit. Then you have more than 50 pretrial motions were litigated and resolved. That's also an enormous amount. 50 pretrial motions. A lot of these are generally involving around evidence, what evidence is allowed to be presented to trial. This is crucial, as we're going to see, because a lot of it, what if a jury is making a decision, well, what is a jury listening to? What's going to be influencing the jury? So obviously one side wants every single fact that can help them to be able to go in front of the jury, for the jury to be sympathetic towards them. And the other side wants to limit it and say, oh, that stuff's just irrelevant. That's just going to invoke sympathy to the jury for no reason. A classic example of this is sometimes in criminal cases when a defendant is being charged, you can't show pictures of the crime if they're overly gruesome, if they're overly horrific, because it's going to say it's playing to the emotions of the jury. It's a shock and awe, saying to the jury how horrible this thing was that happened to the victim, and it's going to automatically make the jury more sympathetic to the victim, which means they're going to be more suspicious by default of the defendant, and they're going to say, well, it's horrible what happened to the victim. That doesn't mean that the defendant is the one responsible. That's at least what the defense would be. So that's kind of where this can come into play. On November 9th, 2023, the jury returned a verdict in favor of the Kowalskis and all remaining claims. And that was it. And that's what gave them, initially actually was a $260 million verdict. And the judge reduced it. The judge said, actually, that's too much. And probably because the judge was also concerned about the appeal and that the appellate court would reduce it and wanted to show the appellate court that he was being very kind of cautious and wasn't giving things just because the jury wanted it, but he was doing it in a very judicious manner. And the judge reduced it to $213 million, which is still an enormous amount of money. Now, here's where we get to the relevant statute. Section 39-2031A, immunity. Pre-trial, JAC moved for partial summary judgment based on the immunity afforded pursuant to Section 39-2031A. Okay, summary judgment. What does that mean? That means that you're saying there's no dispute as to the facts, right? Everybody agrees to the facts. For example, John punched Bob in the face. Bob suffered a broken nose because of that. No one disagrees. However, John could say, well, there's a law that entitles me to punch John in the face whenever I want to. So therefore, I agree I punched John in the face, but there's a special law that says Bob can punch John in the face whenever he feels like it. I'm making up an extreme example, but that's the basic idea, that one side says the facts are not in dispute, but the law doesn't matter. The law will never permit them to win, even if we give them all the facts that they want. And that's what the hospital is arguing here. They're saying, as we'll see, The statute says they're always immune from liability, almost no matter what. Okay, Section 39201A, addressing the mandatory reporting of a child abuse, and provides, in relevant part, any person who knows or has reasonable cause to suspect that a child is abused, abandoned, or neglected by a parent shall report such knowledge or suspicion to the department in the manner prescribed by subsection 2. So it makes it mandatory. And you can also see why the hospital is fighting this so hard, in fairness to them, because the statute says they have to, and they don't want to be accused of not complying with the law. Now, some statutes might say something like they may do something. May means they're allowed to, but they're not required to. Shall means you are required to do this. And if you don't, you're breaking the law. Physicians, nurses, and hospital personnel engaged in the admission, examination, or treatment of persons, as well as other health or mental health professionals, are required to provide their names to the abuse hotline when making a report. Suspected child abuse by a parent must be reported immediately. And any person who is required to report known or suspected child abuse and who fails to do so commits a felony. So extraordinarily harsh penalties. So the hospital is obviously like, well, we don't want to get charged with a felony. So we're going to err on the side of protecting ourselves and reporting it. Almost consequences be damned. And again, maybe this is a problem with the statute. Maybe the statute needs to be reworded. But you can see the tension here between the hospital trying to cover itself and the consequences, intended or unintended, that might result because the hospital was being perhaps overly cautious. The statute goes on and says, any person, official, or institution participating in good faith in any act authorized or required by this chapter, or reporting in good faith any instance of child abuse, abandonment or neglect to the department or any law enforcement agency shall be immune from any civil or criminal liability which might otherwise result by reason of such action. So in other words, if they reported it in good faith because they had a good faith basis to believe there was child abuse, and therefore acting in good faith, they reported it, and then something bad happened, like they're arguing happened here, because they reported it, well, they're going to say, well, we should be immune because the statute says we're immune. And there was another court, which is being cited to here, which concluded that there are two ways in which a doctor can be immune from civil liability for making an incorrect report of child abuse. Immunity exists as a matter of law if the doctor has reasonable cause to suspect that a child has been abused and makes a report of the abuse as required by law. In that event, there's no need to determine whether the doctor acted in good faith. Once reasonable cause has been shown, a reporter complying with the statutory mandate to make a report is by definition operating in good faith. So, if we say there was reasonable cause, then by definition, they're acting in good faith. And if there's no reasonable cause, well, as we're going to see, that doesn't necessarily mean it's not good faith. It just means, okay, well, now we need to investigate further and see, even regardless of the fact that there was no reasonable cause, could a case still be made out to say that they were acting in good faith? And that's what the statute says. However, the absence of reasonable cause does not prove liability, right, like we said. It merely removes the immunity that would otherwise apply as a matter of law, meaning it's no longer a matter of law, it's now subject to a factual dispute to determine whether or not there was good faith. If the objective evidence does not support a conclusion that the doctor had reasonable cause to make the report, the doctor may nevertheless claim immunity from civil liability showing that the report was made in good faith. So reasonable cause equals good faith, but good faith does not necessarily equal reasonable cause. Again, now citing another case, court in Ross likewise concluded that if a reasonable basis existed to report child abuse, the motive in making the report is irrelevant. Based on the facts before and the above cited precedent, the trial court determined very easily that JHAC had reasonable cause to report suspected child abuse to the department hotline. So the facts before presumably are the discrepancy between what JHAC observed as Maya's medical condition and the fact that Mrs. Kowalski was demanding that her child receive these extremely high doses of ketamine and JHAC thought really just did not comport with her actual medical condition, and the fact that this kind of dosage of ketamine can be very, very dangerous even in some situations. Again, it's a narcotic, it's a heavy narcotic, very heavy dosages. You do not want to take it lightly. You do not want to take it for no reason. It should be taken only with extreme caution if necessary. So they're saying this and they're saying, well, maybe the mom is up to no good, so we should report her. Accordingly, the trial court found that Jack was entitled to Section 39-2031A, immunity from any civil claim which might otherwise result by reason of the report. But the court said nothing of immunity for claims resulting from participation in good faith in any act authorized or required by Chapter 39. So we have two things here. You have the fact that the phone call was made to the hotline, so that they're immune. But what about all these other things that they're saying the statute authorized them to do? And they're just acting in accordance with the statute is what the hospital is saying. And the trial court didn't say they're immune from that. And this is where the appellate court is going to take issue with the trial court. But to be clear, it's not clear to me, and I think it's not clear from the record, and I think this is one of the problems with this appellate court decision is all these other things, that these bad behaviors, the mom, again, the social worker telling the mom, the social worker telling the dad to divorce her mom, the social worker lying to Maya, saying your mom's in a mental hospital, Maya being verbally abused, saying we don't believe you, saying it's on her head, maybe even being denied the right to see her parish, all those types of things. Is that participation in the statute? I understand the statute says, okay, now the department is authorized to shelter her from her parents, so you could argue the restriction of visitation is authorized, but how far does that go? What else is covered under that umbrella? So clearly the trial court did not think that all these other things that the hospital did was covered under the umbrella. The appellate court, as we'll see, seems to think it should have been. Within the text of Chapter 39, the legislature established its intent expressly. The purposes of this chapter are to provide for the care, safety, and protection of children, and to prevent the occurrence of child abuse, neglect, and abandonment. All very, very good. Again, I can get behind that. It's all good. The legislature further stated its intent that Chapter 39 be liberally interpreted and construed in conformity with its declared purpose. Okay, so they're saying, well, the statute can't possibly account for every single fact or circumstances that might arise. So anybody who's faced with that statute, they should be given leeway to interpret it as broadly as they want, to do other things beyond the narrow text of the statute. Now, here we go. Here, the trial court erred in not considering the entirety of Section 39-2031A and its application to the facts of this case beyond JAC's immunity from claims premised on or immediately resulting from the reports of suspected child abuse. And nothing in the record suggests that JAC's participation in implementing the dependency court orders as it was required to do so was not done in good faith. Okay, there's two problems with that. One is, are the acts that the Kowalskis are suing upon, are those acts that stem from implementing the dependency court order, Or is it saying that the hospital did things that were beyond the scope of the dependency court order, and that's a problem? That's A. B, if the hospital is obviously saying, oh, what we were doing was just implementing the dependency court order, and now the appellate court is saying there's nothing that says it was not that any act that you took was not done in good faith. Well, the jury awarded them over $200 million. So the jury, I think, would beg to disagree. So appellate court does not have the ability to contradict a finding of fact made by a jury. That's the province of the jury. All the appellate court can do is decide the law and say, was there a mistake of law that happened? So for the appellate court to now say that nothing in the record suggests it was not done in good faith, well, it seems like the jury had 200 million reasons to say it was not done in good faith. But that's just me. This is not to suggest that Section 39-203(1)A provides absolute immunity. Okay, I mean, well, if this, it seems like it is providing a lot of immunity. And if this situation is a situation where they're not, where they're still immune and it still comes under the immunity, well, then what would be a situation, according to this appellate court, where a hospital can ever not be immune? Because if this is immune, it seems pretty close to absolute to me. The appellate court continues, it provides immunity from liability that might otherwise result from good faith reporting or good faith participation in acts authorized or required by the Chapter 39. So again, I get it. That's where it provides liability from. But what they're not telling us is what would be a situation then where the hospital is not immune. They're just going to keep saying, oh, they were acting in good faith, acting in good faith. Well, what can ever be considered not good faith then? It seems pretty clear that the jury thought it was not good faith. The trial court found as a matter of law that Jack had a reasonable basis for suspecting that their patient was the subject of child abuse, that Jack acted in good faith in reporting that suspicion, and that Jack could not be held liable for any cause of action directly arising from sheltering the child pursuant to court order. So sorry, just to back up, this is from the Florida Hospital Association. They filed what's called an amicus brief. An amicus brief is where you're third party and not a party to that case, but you think the ruling on that this court comes out with will somehow impact you, and therefore you're going to pick a side and you're going to file in support of one of the two sides because you think it's an important issue and you don't want the issue to come and negatively impact you in another way. So obviously the Florida Hospital Association is going to write a brief in favor of the hospital because they sure don't want to ever be dragged into this type of thing. So what do they say? Unfortunately, these findings were rendered meaningless at the trial itself when the court permitted the Kowalskis to attack J.X. basis for suspecting abuse, its motives for reporting that suspicion, and presenting evidence to the jury of the psychological impact of the court-ordered sheltering period. The actions of JHAC with respect to the good faith mandatory reporting were repeatedly called into question and leveraged by the Kowalskis in their effort to secure a finding of civil liability and an award for damages. Okay, so, well, there may be something to that. Again, to be fair, it was a very long trial and a lot of evidence. What the point that they're missing is not what the hospital did to implement the court order, but it's whether or not what they did was, well, beyond the scope of that court order. Is this part of sheltering, or is this something way beyond sheltering that was not even authorized by the court order? Or even if it was authorized by the court order, well, does that give them a carte blanche to do whatever they want? The hospital association is saying, well, their good faith was attacked, even though the trial court said at the beginning that their good faith was established. And they were, that was not even a question. But there's two different acts. The trial court said only that the reporting was done in good faith, not the social worker saying to the hospital, saying to Mr. Kowalski that you should divorce your wife, not that the social worker is now allowed to lie to Maya and tell her mom's in a mental hospital. Again, where's the good faith in that? Where is that a participation in good faith of the sheltering order? It seems to me those are the core things that went way beyond it. Now, just to wrap up, the trial court implicitly recognized that the dependency court orders, that is, those sheltering a child and restricting or prohibiting visitation, may result from the reporting and investigation of abuse. Okay, but it's not just the fact that there was a restriction, it's how the restrictions were implemented. There's quantity and quality. So you can have the quantity, less time, but how? Does that mean that you can regulate every single conversation? Does that mean that you can say that you can't talk to a child in your native language? Yeah, the trial court failed to give effect to its interpretation by permitting the jury to hear significant and inflammatory testimony. Well, I'm sorry. Yes, it was inflammatory because the hospital screwed up. If the hospital had not screwed up, it wouldn't be so inflammatory. Concerning the restrictions put in place by the dependency court and the impacts of those restrictions on the Kowalskis. All right, so I think that's where we're going to finish up in terms of the order. The rest of it goes on about false imprisonment, intentional infliction of emotional distress. I wanted to get into just that statute and where I think this is all going. Why do I think this is a very good case to go to the Florida Supreme Court? The hospital is claiming, and now the Florida Appellate Court is agreeing that this immunity provision gives them almost carte blanche to do whatever they want. And my view is, if this decision is allowed to stand, when are you ever going to have a case where a hospital can be held liable? Any hospital will always say, well, if in this case there's a ruling that we are immune, then certainly in all these other cases, which presumably the facts are hopefully not as bad, then we're certainly immune. Or even if they are as bad, well, they're immune here, we should be immune. So I believe, in my opinion, and you guys tell me what you think in the comments, this is certainly a question of great public importance. You have issues of treatment of a child, you have issues of patient care, you have issues of the right parental rights, a fundamental right to parent your child and to raise your child. You have issues of the quality of what a hospital can do and cannot do, which I think certainly need guidance if a court order is in effect that says they have to shelter the child. And to simply say, no, once there's a court order that says you have to shelter the child, nothing else matters, you can do whatever you want, I think goes way overboard. And if the Florida Supreme Court does not step in and does not correct this, I believe it's setting a very, very bad precedent. It's going to happen again, and it's going to get even worse. So that's my take. Hope everyone enjoyed. Don't forget to like, comment, and subscribe. Tell me what you think. If there's any other topics regarding this you'd like me to cover. And until next time, we'll see everybody on the next one.